to the PI Show, viewers. My name's Tony Carbone. I'm a personal injury lawyer. Next to me, I've got John Carancis.
Tony.
Personal injury lawyer of many years and run quite a few trials, and probably one of a few blokes that's run a couple of very successful and big cases last year, John.
Yes, good evening, viewers.
And Kathy, you've been a stalwart of the show for some time now. So
I have. I'm part of the furniture. Good evening, viewers. Good evening, John, Tony. Thank you for having me again.
And tonight we're going to be talking about the meat industry and all the accidents that occur in abattoirs and how that industry there's got quite a few deaths and very significant injuries, and how the premiums of the employees in that industry are so much higher than everywhere else, John.
Yes.
But Tony, before we get into such an interesting and topic, I should say, we want to hear what's in the news. Viewers love this part of the show, and we need to know current affairs.
Kathy, soon we're doing the subject of the meat industry and abattoirs. What's in the news is a story about a 17-year-old meat worker, Sharga Tate, who was working in the Wonthaggi Tabrone Meats, and he was working in an area, a controlling box it's called, where they take the cows and they're stunned before they're slaughtered. Whilst he was in there, the machine started up unexpectedly and he was crushed. So it's a very, very tragic story. He also had a child, and John, this one here, 17-year-old, there's a claim there for the dependents, which is a child.
Yes, it's a significant claim. Under statutory benefits in the Victorian Work Cover legislation, the dependents are entitled to sue for damages against the employer.
But the no-fault benefit's pretty big. It's over $500,000, I think. But it's a tragedy that shouldn't have happened. So, you know, this is the topic we're doing tonight. So it's a good way to start the show, I think, guys.
Definitely. It's very sad that things like that happen, and it's obviously there's duty of the employers as well. So why don't we get straight into it so that we can hear more about the topic?
Yeah, look, just last year, viewers, in the meat industry, there was 355 workers' compensation claims. And in those cases there was at least 10 days off for most of the workers. The illness rate's 4 times the average of any other workplace. The insurance premiums are 7.72%, which is a lot higher than the industry average of 1.39%. And so it's just an area where there's a lot of problems, John.
Of significance, Tony, $132 million has been paid out by the work cover authorities in regards to injuries sustained at these type of places.
Well, Kathy, 355 workers doesn't sound like much, but then on the numbers that John's just given, they're pretty big, aren't they?
That's right. It's because they're more significant claims, and it's of the fact that 355 may not sound like a lot, but when it's within one industry, it is a lot in comparison to other work cover claims as well.
That has been in the past decade. However, well, you and I both know, Tony, over the last few years, we've been involved in significant claims with abattoirs and the meat industry. They're dangerous places to work in.
Yeah, but even though they're dangerous places to work in, there's a very, very strict regime of occupational health and safety these days, and don't we have to protect these workers?
The employer is required to provide the worker with a safe workplace. That's no matter what.
In fact, under the accident compensation system, there's about 30,000 accidents of all descriptions, and so for 355 of those to warrant the amount of payouts that you've just mentioned, John, just shows you it's a very, very tough industry to be in.
I think of significance is the type of injuries that are sustained in these type of places.
Well, there's a lot of loss of limbs and fingers and thumbs and crushing and all sorts of things. But look, why don't we do the first case that we're talking about, a case of Tatara Meat Company and Tyrone Kelso. Now, Tyrone Kelso was a young man working in the meat industry, and in 2001, he cut off the tip of his thumb. Now, in 2004, he commenced proceedings in a county court to obtain a serious injury certificate so he could proceed with a claim for damages. And his case went to court in 2006, and his case was dismissed.
The judge found at the first instance the consequences were not great.
Well, just to give you a bit more information about this fellow, he was 19 years of age. Before his accident, he was a very, very good footballer. There was some suggestion he could have gone into the AFL. That's how good a player he was. He was a very active bloke. He worked in the meat industry. He was a very, very young man that was very, very active. Now, when he had his accident, after 3 months, he went back to work. He went back to work in a different job, then went back to work for the same employer that he got injured in. Why would he have lost his case, Kathy? What?
Well, firstly, he didn't go for economic loss, I take it, Tony, because of the fact that he's returned to work. It's pain and suffering. Well, it's an interesting question. I'm waiting to find out the answer from you, but I would assume that the reason would be because the consequences of the pain and suffering that he endured wasn't great, or that the injury wasn't severe enough to warrant a serious injury.
I don't know, losing a tip of your thumb sounds pretty horrific to me, and I would have thought that that would warrant a certificate on its own, John.
I guess, in one sense, it depends on whether or not it's the dominant or non-dominant hand, Tony. That's a factor.
Let me tell you a bit more about the facts. This fellow here, when he was playing football, in the end, he went to full forward. He said he wanted to play full forward because he didn't have to run around and bump and all sorts of things. And what he also said was he didn't take overhead marks, and most of his marks were on the chest. So he was trying to protect his hand as much as he could. He also didn't have a lot of treatment, didn't take too much medication, wasn't getting any physio, and he went back to full-time work. Yeah. So even though the injury in itself seemed serious...
what are the consequences?
Yeah. So you say just the fact that you've lost your thumb and you're a bit more resilient than most people, that doesn't justify a certificate?
Well, it depends on the circumstances. And you would think how about under disfigurement, Tony?
Yeah. No, look, the finger was reattached. The thumb was reattached. So,
right.
But he said it was painful when it was struck. It was causing him problems with the hand. But no, disfigurement wasn't the way to go, John.
I personally give him credit for actually trying to go back to work and not allowing this to take over his life and trying to get back to football as well. I think that's commendable for someone that's suffered a loss of a body part, to some degree anyway.
That's a good point, Gaff. He didn't seek to embellish his injuries, this fellow.
That's right.
And he tried to get on with his life. Sadly, getting on with his life, John, cost him a chance to get some sort of compensation for a very nasty injury.
So Judge Mullane, at first instance in the county court, said he has no serious injury. His lawyers have appealed it to the Court of Appeal of the Supreme Court. And what's happened there, Tony?
Well, they've heard the evidence. They've gone through the transcripts. They've gone through everything. They considered They considered it very, very carefully, and they found against him as well. Anyway, we've got to...
Viewers, please stay tuned. We're going to keep bringing more after the sponsors break. Thank you.